What is CCPA? California's Consumer Privacy Act gave California residents powerful new rights over their personal information and created significant compliance obligations for businesses worldwide. In the next few minutes, we will break down the CCPA and its 2020 expansion under CPRA, covering consumer rights, business obligations, and what it takes to comply. Let us get started. Let us begin by defining what CCPA is and the problem it was created to solve. The CCPA, effective January 2020, is California's comprehensive consumer privacy law that grants California residents specific rights over the personal information businesses collect about them. The CCPA, effective January 2020, is California's comprehensive consumer privacy law that grants California residents specific rights over the personal information businesses collect about them. The California Privacy Rights Act, effective January 2023, expanded the CCPA by adding new rights such as the right to correct, creating the California Privacy Protection Agency, and introducing sensitive personal information protections. CCPA applies to for-profit businesses doing business in California that meet at least one of three thresholds: annual gross revenue exceeding $25 million, processing data for 100,000 or more consumers, or deriving at least 50% of revenue from selling personal information. CCPA grants consumers the right to know what personal information is collected, the right to delete it, the right to opt out of its sale, and the right not to be discriminated against for exercising their rights. CPRA added a specific category of sensitive personal information, including social security numbers, health data, and precise geolocation, with stronger restrictions on processing and a new right to limit its use. For key terms underpin the CCPA framework. Personal information under CCPA is broadly defined to include any information that identifies, relates to, or could reasonably be linked to a particular consumer or household, covering far more than just names and contact details. The right to opt out of the sale or sharing of personal information must be supported by a prominent "Do Not Sell" or "Share My Personal Information" link or button on the business's website and mobile app. The California Privacy Protection Agency is an independent state agency created by CPRA with authority to issue regulations and enforce the law, representing a significant escalation in California's privacy enforcement capacity. A service provider is a company that processes personal information on behalf of a business pursuant to a written contract that restricts the provider's use of the information to the services specified. Now let us walk through how CCPA operates in practice. Implementing CCPA follows a structured, systematic approach. Compliance begins with mapping all personal information the business collects, identifying the categories, sources, purposes, and third parties it is shared with. The privacy notice must disclose the categories of personal information collected, the purposes for collection, the consumer rights available, and how to submit requests. Businesses must establish a process for receiving, verifying, and fulfilling consumer requests to know, delete, correct, and opt out within the required 45-day response window. A prominent opt-out mechanism must be implemented on all digital properties, and third-party data sharing and selling must be managed to honor opt-out requests effectively. Contracts with service providers must include the required CCPA terms restricting their use of personal information and establishing their compliance obligations. CCPA compliance flows from data inventory through privacy notice updates, consumer rights processes, opt-out mechanisms, and vendor agreements. Data inventory. Let us explore why CCPA delivers significant value to organizations. CCPA delivers measurable value across the entire organization. CCPA compliance is a legal requirement for all businesses meeting the applicable thresholds, and failure to comply exposes the business to enforcement actions and private rights of action for data breaches. Businesses that clearly communicate their data practices and make it easy for consumers to exercise their rights build stronger trust and differentiate themselves in privacy-conscious markets. A well-implemented CCPA program reduces the likelihood of regulatory investigations and the risk of class action litigation following a data breach under the CCPA's private right of action. The CCPA compliance infrastructure, particularly data inventories, privacy notices, and rights processes, provides a reusable foundation for addressing the growing number of U.S. state privacy laws. Let us compare businesses handling California consumer data without CCPA compliance versus those with it. Without CCPA compliance, businesses cannot respond to consumer rights requests, lack the disclosures consumers are entitled to receive, and face significant enforcement and litigation risk from regulators and affected individuals. With CCPA compliance, businesses have the processes, technology, and contracts needed to honor consumer rights, make required disclosures, and demonstrate accountability to regulators and customers. Let us bring together the essential points from our introduction to CCPA. If you want to implement CCPA compliance step by step with practical templates, our complete Udemy course covers every requirement and consumer right. Enroll today and build your California privacy program. Thank you for watching. If you found this helpful, please like and subscribe. See you in the next video.